Okay, thank you all for joining us for Guardianship versus Power of Attorney, for families members with disabilities webinar on May 16th, 2023 at 6:30 p.m. Guest presenter is Kelly Hayes from McAndrews, Mehalick, Connolly, Hulse, and Ryan PC. Our disclaimer, the ARC of Lehigh Northampton County's Advocacy Department does not employ lawyers nor provide legal advice. This training or any others provided by the ARC's Advocacy Department does not constitute or imply the endorsement, recommendation, or favoring of the providing party or any employees or contractors acting on its behalf. This webinar is being provided for educational and informative purposes only. Thank you for that. And now it is my pleasure to introduce our guest presenter, Kelly Hayes, who is an attorney in the Estates and Trust Department in the McAndrews. I'm not even going to pronounce that location. There we go. One of their offices. You guys have many different locations. She specializes in estates planning and estates and trust administration. Kelly works closely with her clients in creating estates planning documents tailored to the individual's needs. Kelly received a BA from Villanova University and a JD from Widener University of Law, where she achieved Dean's List honors. While in law school, Kelly earned certificates of achievement for receiving the highest grade in federal estates and gift tax, estates planning, and insurance law. Today, Kelly lives in Delaware County with her husband, 2 children, and an eccentric dog. Okay, thank you for your time this evening. Enjoy, and Kelly, the Zoom is yours.
Okay, well, thank you very much. Thank you, Cody and Susan and Jessica and the ARC of Lehigh and Northampton counties for having me. And just like Cody said, if there's any questions that you have during the presentation, ask them, and then we'll try to address them if they fit in. If I think that they're going to be answered later on in the presentation, I'll let you know. If I skip you, I might just wait till the end if it's not really fitting in with what we're talking about. But by all means, if something comes to your mind, just put it in. I think you have several options, right? The chat, the Q&A, whatever you want. I am going to attempt to share my screen. Let's see if I can do it. We did it earlier.
Yeah.
That's working. Okay.
It's coming up.
So tonight we are talking about guardianship versus powers of attorney and how you make decisions for a family member with a disability and what options there are for you. Let's see. There we go. So power of attorney versus guardianship. Just like a quick overview. A power of attorney is a document that grants another person, so your agent, the authority to act on your behalf. The person signing the power of attorney is called a principal. The principal retains the right to act. So just because you sign a power of attorney doesn't mean that you can no longer make decisions for yourself at that time necessarily. Guardianship, on the other hand, is a legal determination. You have to go through a court process that a person does not have the capacity to act on his or her own behalf. There has to be no less restrictive alternative. So we really want guardianship to be a last resort. When you are going through guardianship, what you're doing is you are kind of taking away a person's, I guess, depending on the type of guardianship that we're talking about, and we'll talk about a couple, you're potentially taking away their rights to make decisions. So the courts, and obviously we all want to always promote self-determination, autonomy. So like we want to make sure that we are making sure guardianship is in fact the least restrictive alternative. If there's other things that we can do to enable a family member to make decisions, and we'll talk about a few alternatives. So the power of attorney, we'll talk about supported decision making, we'll talk about the healthcare representative statute, we'll get to all of them in the presentation, but they would all be considered less restrictive alternatives to the guardianship. But with that being said, there are always situations where guardianship is appropriate. So we'll go through guardianship so you know what you're dealing with there as well. So courts prefer the power of attorney over guardianship when possible. Again, for those same reasons, we want to promote that self-determination and autonomy. We don't want to take away a person's decision-making ability unless absolutely necessary. And again, yeah, I should have probably, but guardianship is only necessary if the incapacitated person didn't previously execute a power of attorney. I'll tell you, one of the things that I'm always telling clients when we're executing estate planning documents is you're signing this power of attorney now. In it, we usually appoint people or nominate people that we would want to serve as guardians in the event that guardianship does become necessary. But I always kind of throw in the caveat that it's highly unlikely if you have this valid power of attorney and there aren't some other issues going on. So again, the goal of the power of attorney is you have that person who can basically do for you financially, if we're talking about a financial power of attorney, or medically, if we're talking about a healthcare power of attorney, anything that you can do for yourself. So especially in the financial context, dangerous document, but excellent estate planning tool. And I know we're talking about family members with disabilities, but again, everyone, kind of regardless of disability status, should really consider having a power of attorney in place. I think I read a statistic that 1 in 4 adults has some type of disability, and once you reach the age of 75, you have about a 75% chance of becoming incapacitated, so not being able to make your own decisions. So having this document in place, I mean, particularly if it ends up being durable, it survives any incapacity, so you're always set. You're never going to need to go through guardianship proceedings if they're not necessary. So let's talk about some legal terms. So the person who is creating your power of attorney is always called your principal. The agent is the person that is designated by the principal, so the person making the document to act on their behalf. Sometimes you'll hear the term attorney in fact. I mean, that's going to be kind of the same thing as your agent. What is the power of attorney? In general terms, it's a written document. You have your principal giving your agent the authority to act according to the terms and conditions set forth in the document. We have a financial power of attorney. We have a healthcare power of attorney. So kind of obvious, financial power of attorney, agents doing financial things for you. Healthcare power of attorney, making medical decisions. Sometimes those healthcare power of attorneys will contain living will provisions. Sometimes there's a separate living will or advance directive. In our practice, a lot of times when we have someone who's just turned 18, so family is looking to make sure that their mom or dad or family member have the ability to get information, make decisions when necessary, we use what we call like a combined power of attorney. So it's a general durable power of attorney that has both healthcare and financial powers, and it wouldn't have any like living will provisions in it at the time. We sometimes find that they are easier for our clients to understand, grasp, and complete, so that mom, dad, or other family member have the ability to act for them when necessary. One of the, I guess, significant differences between power of attorney and guardianship is with the power of attorney, your principal, so again, the person who made the document, retains the right to act, and they can revoke the power of attorney at any time. So you can, as long as you have the capacity, and we'll talk about that on the next slide, as long as you have capacity, you can revoke your power of attorney. You can create a new one, I mean, every day of the week if you wanted, although that might become cost prohibitive. I was just checking the chat. I saw something in there. So what is capacity? So you need capacity to make a power of attorney. Capacity is a very low bar. So for making a power of attorney, you need a general understanding of what's happening. You have to be oriented to time, person, place. So you basically need to know the people around you. You need to know where you are. And I mean, if you told me it was 1972, I know we have a little bit of a problem. We're going to have to like dig some more into that. So you basically have to know what's going on, and you have to understand the power that you are giving someone. So in the most simple terms, like you understand that you need help with financial or money matters, and you want an individual to help you with those. We always talk about it in the sense of a team. So we're kind of putting your team in place right now. So we know that if you're not able to act for yourself, or if something comes up and you need help, like we're building your team, you have your team in place to help you. Same thing with medical decisions. You'd have to know that you need someone to help you. You want someone to talk to doctors, talk to insurance companies, things like that. So we can usually break it down that way to make sure that the client understands, because the attorney is typically the person who's making that capacity call. So when you're doing a power of attorney and you have the lawyer say, oh, okay, we need you to come into the office, we need to talk to you first, they're generally not just being pests, they're not trying to run up your bill or anything like that. We do have an obligation to make sure that the individual signing the document has the capacity to do so. They know what they're doing. Then in my practice, typically after that meeting, we'll draft it and then we'll bring you back and sign everything. So give you some time to digest, look over everything.
There is a question in the chat on how is capacity determined if the individual is nonverbal?
That becomes a little bit more difficult. So again, like you're leaving, it's up to the attorney to determine kind of, is there an understanding there? If there's like sometimes just like nodding up and down, I don't know if that's like enough for me to like understand that that's what you want to do. So it really becomes fact specific, case specific. If there's any other like means of communication, sometimes there's those like computer programs where the person can kind of touch the letters or say the words, things like that. There's probably a much more sophisticated name for that than the computer program, but the kind of things like that are how we're going to judge that capacity. So I think there was another question that was pre-submitted that was on the along the same lines, like if you can't read or write, like, I mean, we do really need to make sure that you can understand, like there, particularly with the financial power of attorney, there's a statutory notice that Pennsylvania makes us put on the document, and it's all in like caps lock letters. And we have to go through it. Like usually the client has to read it and acknowledge it, or make sure that it's been read to them and they understand kind of the contents. Again, because if you think about it, particularly that financial power of attorney, you are giving someone a lot of power, like can do anything for you that you can do for yourself financially. So we want to make sure that you understand the powers that you are giving to another individual. If you can't sign, you can definitely make a mark. So you can sign by mark, you can sign a power of attorney, you can give direction to another person to do it on your behalf. I had a client before who was a quadriplegic. He, from the neck down, wasn't able to do anything, so he could direct his dad to sign on his behalf. If that's what you're doing, the person who's signing on behalf can't be a witness or a notary, so you're going to need some extra people with you.
Okay, because you mentioned notary, because that had to do with like the second question below that. How would capacity be determined if the power of attorney is being signed in front of a notary instead of an attorney?
Usually an attorney is usually preparing the power of attorney. It gets a little grayer if you're like pulling the document off of the internet and then just having someone sign it. I mean, sometimes that works out. Other times you really do want to make sure that you're kind of structuring the power of attorney to do what you want to do, make sure it has the specific powers that you need in it. If there's ones that maybe don't apply, I would recommend, especially if there's a capacity issue, to talk to an attorney. These documents, they've been pulled off the internet with no attorney involvement. The notary is not making a capacity determination. So, I mean, that can typically, I know Mr. Lissinger, but let's see. I was thinking, so if you don't have the attorney making the capacity decision, if you're just pulling it off the internet, like a notary is not, all the notary is doing for you is verifying that the person who says that they are signing the document is signing the document. So if capacity is challenged down the line, you don't have the attorney who can then come to court if it's being challenged and say, okay, listen, I met with Mrs. Smith on this day. We talked about these things. If we keep very copious notes, if there is an issue about capacity, sometimes we'll even record meetings. So, I mean, there are just kind of some ways that we handle potential issues with incapacity. But yes, if you're just pulling a power of attorney form off the internet and having it witnessed and notarized, there is no one making that capacity determination. So if you have a sister or brother or another family member who's going to contest it, I mean, they could very well do it. And by contesting it, they're probably going to petition for guardianship.
Okay. Sounds good. Thank you. I think that was like the only one that really went with that PowerPoint slide for now.
And then Cody, there is a question, an anonymous question, but it has to do with guardianship. So if you want to wait, Kelly,
yeah, we can wait on that one.
You want to wait on that one? That's fine.
Yeah.
Okay. And we will get to that. So about guardianship. Let's see. Okay. So when you have a power of attorney, you have a durable power of attorney, which lasts past incapacity. So I always tell people once you sign it, doesn't matter 10, 15, 20 years down the line, if something happens, if it's still a valid document, it'll survive any future incapacity. Unless otherwise stated, all POAs are presumed durable. Some people don't like giving all of that power to an agent, which is understandable. And it really just depends on who you're picking as your agent and the relationship that you have with that person. Another option is a springing power of attorney. A springing power only goes into effect after medical professionals, it's usually 2, have certified that the principal is incapacitated. So you need doctors to certify incapacity before the agent can act. Sometimes there's interpretation problems. If your principal is temporarily unavailable, so let's say they're out of the country and they need something done, or something happens, if they need someone to sign a deed for them and they wanted their power of attorney to do it, if they're not incapacitated, you're not going to be able to do it with a springing power of attorney. These are just as kind of like a selection of some powers that an agent under a power of attorney has. Engage in banking and financial transactions, create trust, real property transactions, to make gifts, limited versus unlimited. When someone asks me to review a power of attorney, I'll tell you the gifting language is always something that I'm looking for. Gifting, although it sounds a little bit intimidating, why would I want to have these gifting powers in my power of attorney? If you ever need to do long-term care planning, if you ever need to do Medicaid planning, the gifting powers in a power of attorney are what are going to allow your agent to kind of move assets around, do different things, particularly if there's a spouse involved, if you need to move assets to one spouse to qualify another spouse, something like that. The unlimited gifting powers are what become very important. So that's what I'm always looking for when someone's like, can you review this power of attorney? Let me know if you think it's okay for now or if I need to review it. Engaging in insurance transactions, receiving, applying for government benefits. You can even help doing your taxes, although I will put the caveat in there that the IRS has their own form that they usually like submitted with a copy of the power of attorney. More powers, and these aren't all the powers, I just was we were pulling a few. Provide for personal and family maintenance, make advance arrangements for funeral and burial, authorize admission to medical, nursing, residential facility, authorize medical, surgical procedures. I kind of split them a little so you can see like the first slide here was a little more financial. The second one is a little more medical. Also to your healthcare power of attorney is considered a authorized recipient for HIPAA purposes. So they'll be able to get information from doctors, medical providers about you. Another very important power to make sure that your powers of attorney have concerns digital access. Not as important like 10, 15 years ago, but now particularly because a lot of people do online banking. They do a lot of things go to their emails. You get all your statements come to your email. They're not coming to the house anymore. If you lose capacity, if you're not able to give someone else this information, you want to make sure that your agent has the ability to access this information for you if needed. So we always want to make sure that there is revised uniform fiduciary access to Digital Assets Act information in our powers of attorneys too. What is the agency relationship here? So an agent under a power of attorney, you have to sign an agent acknowledgement at the end of a power of attorney, which typically serves as a specimen signature. And then it's also you acknowledging kind of what you are going to do and like kind of the responsibilities that you have for your principal. So you're signing and you're stating, and the agent's duties are statutory, that you're exercising powers for the behalf of the principal. So you're only doing things for the benefit of your principal. You're keeping assets separate from the principal. There's a little bit more of a gray area when we're talking about spouses, things like that. Exercise reasonable caution and prudence, and you're keeping full and accurate records of all of your actions, receipts, and disbursements. This becomes very important too if someone is going to challenge anything you did with your power of attorney down the line and they request an accounting. Making sure that you have accurate records is kind of a good way, not only to show that you are kind of taking your fiduciary duty seriously, kind of making sure all your T's are crossed, I's are dotted, but it's also going to protect the agent in the future if there's ever an issue. Guardianship. So that was a brief overview of power of attorney. Now we'll do kind of a brief overview of guardianship. So guardianship statutes are set out in Title 20 of the Pennsylvania Consolidated Codes at Section 5502. And this is kind of the beginning introductory kind of paragraph to the guardianship statute. And what I've highlighted is, so like what you're trying to do is this is what the actual statute says, that we recognize that every individual has unique needs and differing abilities. It's the purpose of this chapter to promote the general welfare of all citizens by establishing a system which permits incapacitated persons to participate as fully as possible in all decisions which affect them, which assists these persons if meeting the essential requirements for their physical health and safety, protecting their rights, managing financial resources, and developing or regaining abilities to the maximum extent possible. And we want to accomplish these objectives through the use of the least restrictive alternative. So again, guardianship, particularly a plenary guardianship, is going to be very restrictive because you're taking away an individual's rights. With all that being said, we recognize further that when guardianship services are necessary, it's important to facilitate finding suitable individuals and entities willing to serve as guardians. So guardianship, again, should be almost like a last resort. There's nothing else, like we need to make decisions, we need to protect the person, there's nothing else that we can do. Generally not needed, like we said, if the individual has the capacity to execute the power of attorney. And we talked about too, that capacity level is lower. So people say capacity, you're like, oh, I'm not gonna be able to do it. It's a relatively low bar. You're asking the court to have the individual declared incapacitated to have a guardian appointed. What is an incapacitated person? The statutory definition is an adult, so someone over 18 whose ability to receive and evaluate information effectively and communicate decisions is impaired to an extent where that person is unable to manage his financial resources or meet essential requirements for his or her health and safety. So guardian of the person, kind of think of this more in terms of your healthcare power of attorney. So a guardian of the person is making decisions for the incapacitated person, such as where they should reside, which medical, social, educational, psychological, and vocational services the person should receive. Guardian of the estate, if we're thinking in the power of attorney context, this is your financial power of attorney. So again, we're making decisions about the incapacitated person's financial assets. There has been a big push in the disability rights community, and in particular counties in Pennsylvania, like some more than others, to really make sure that guardianship is this least restrictive alternative. And sometimes you will even see guardianship of the estate, or the person maybe being appropriate, but guardian of the estate not being appropriate. The things you have to think about, particularly when you're talking about like a young adult. So someone like someone just turned 18, 19, they probably don't have many assets. So the guardian of the estate is only necessary when there's assets to be managed. If you're getting Social Security, you can have a rep payee. The rep payee can manage it. So there's really no need for a guardian of the estate. If you are making sure when you're doing your estate planning, this is more for like mom and dad and family members, that you're directing anything that you're leaving for that individual, with the disability, particularly if they are receiving public benefits, so your Social Security, disability, SSI, Medicaid, you're leaving anything in your estate plan to them via a special needs trust. Again, the trustee in that document is going to be the person controlling the asset. There's nothing for a power of attorney to do. I think I mentioned it later in the presentation too, but like ABLE accounts are another avenue that I would recommend like exploring. So as long as you have a qualifying disability before you're 26 years of age, you're qualified to open an ABLE account. I like to explain ABLE accounts as kind of the cousin of the 529 account. So 529 account, you can put money away for, it used to just be college, now it's a little bit more than that. And then if you're taking it out for educational expenses, there's no income tax liability for any of that gain. Same concept with the ABLE account, put money away for the person who's had the qualifying disability that manifested before 26. That is going to raise to 46, I think, in 2026. There's a lot of sixes going on there, but it'll go up soon. So you're putting money away as long as the beneficiary is using it for qualifying disability expenses, and they're defined broadly by statute. Then again, that income, any income that is earned on those monies, like there's going to be no income tax consequences. One of the big differences between ABLE and the 529 though is the amount that you can put it in a year. You're limited to $17,000 this year. So the number kind of runs with the annual exclusion. So it's cumulative. So if grandma puts in 10, mom and dad put in 5, someone else puts in 2, you're done. It's not like the gifting with the annual exclusion where everyone can give someone $17,000. I segued a little bit. So plenary guardian.
Kelly, it's okay. That's great. Just a couple questions on that particular topic before we move on. Could you give a couple examples of the assets? We had one question just asking for what assets, examples that could be for a person with a disability.
Okay, let's see here. Can more than one person have guardianship? Yes, you can have co-guardians. How will the court decide? We're going to get to how the court will decide when guardianship's appropriate and the requirements for the petition. Kelly asked, many families approach me with concerns because there's no one beyond parents who would serve as guardian. What options do you have in those circumstances? If there's no other family members, there are nonprofits, there are other individual or there's organizations that provide guardianship services that typically will serve in those capacities. It kind of just depends, like on a case-by-case basis. Sometimes the court will appoint another attorney to serve as a guardian. It just really depends. But just because there isn't a family member to kind of step into that position doesn't mean that that person is kind of abandoned. Do you have a, I don't know. Can I share an example of assets? Melissa, I don't know exactly what that means.
That was in your previous slide when you were talking about, how individuals might not have many assets, right, when they're 18. So what would be some examples of assets that they could get?
Assets that are in your own name. So you have to think of, so if they have a bank account and there's no power of attorney. So when I was talking about when you have someone who doesn't have a lot of assets, so who only is getting Social Security, that's like their main source of income. Maybe they have a special needs trust that they're the beneficiary of. Maybe they have an ABLE account. Guardianship of the estate is not going to be appropriate for that person because all of their finances are being managed kind of alternative ways. Guardianship of the estate becomes more necessary when we're talking about like older individuals who have maybe developed some sort of incapacity, developed dementia, something like later on down the line and didn't have powers of attorney in place. So they have homes, they have bank accounts, they have think of any assets that a person might need that need to be managed. So that's when that guardian of the estate becomes appropriate. So not necessarily appropriate if everything's being managed kind of through other avenues. Tax liability up to 100,000 for ABLE. So if you are receiving SSI benefits, so they're those resource dependent Social Security disability benefits, anything over $100,000 is potentially going to impact your SSI benefits. If you are not receiving SSI benefits, the amount in an ABLE account will never impact Medicaid benefits, so it's never going to impact medical. It is not going to impact SSDI because there is no resource requirement. And then the ABLE account limits run with the 529. So they're around like $500,000 right now. So if you're receiving SSI, that's the only time where you have to be kind of cautious of that $100,000 amount. Income tax ramifications or tax liability up to, I don't believe there's any sort of tax liability for ABLE. Again, as long as you are using it for qualified disability expenses, if it's not being used, there's a 10% penalty. Are people people are paid to be guardians. I mean, again, it's really kind of on a case by case basis. There are court appointed, I wouldn't necessarily call them volunteer, but I mean, typically anytime a guardian is getting paid, they usually have to file a petition to get court approval for those guardian fees. I don't know if there's any sort of way to register to do that. You said rent is not included. What did I say? So paying bills, I mean, we'll get to all that a little bit more, but if you have a family member who can help you kind of pay your bills, do things like that, like paying your rent, paying your mortgage, I don't think you're going to need a guardian just for those purposes. I don't know how to make this bigger, so I feel like it's Social Security, you can have a rep payee. So the rep payee is the person who's kind of controlling those funds. If there's a rep payee on the account, they can like make payments for the rent, the mortgage. Again, different topic, but you got to be careful with social SSI, particularly and like what's being paid with it, or where other assets are coming. Congress has been talking about raising that amount of $2,000 in the Social Security account, I think longer than I've been alive. So I mean, hopefully they do something, but I wouldn't hold my breath just yet. I haven't heard any updates that, I mean, it's been moving. I think we addressed the difference between ABLE and 529. 529 is for educational expenses. ABLE is for an individual who's had a qualifying disability before the age of 26 and has to be used for qualifying disability expenses. That is an interesting question that I've never really thought. If you're the guardian of a family member who has children, who has authority over the minors, if for some reason no one's able to take care of the minors, I think they would need guardians of their own appointed. Okay. I am going to go back to this presentation for a minute.
Oh, thank you. No, we appreciate yours.
I think I hit most of them there. There's still a few left.
You did. And just a quick side panel. The ARC will also be hosting webinars in August, specifically on financial abilities for people with disabilities, ABLE accounts, 529, special needs trusts. But if you have specific questions to your specific situation, we're not going to say those out loud here on the webinar because it is recorded. So I do ask that you hold those, and we'll be giving Kelly's direct contact information after this webinar. So feel free to contact her directly. But thank you so much, Kelly.
Sure. So we were talking about plenary guardian. So plenary guardian is when a guardian is appointed by the court when the person is determined to be totally incapacitated. So they have no decision-making ability. So the guardian is going to have complete total decision-making authority. Again, that is a last resort. Courts would prefer, if guardianship is necessary, to appoint a limited guardian. So that's when the person is partially incapacitated. The court may appoint a limited guardian. He'll have powers only over what the court expressly orders. So there might be limited areas where the individual needs help, and that's where the guardian would come in. The incapacitated person would retain all the other powers over his affairs that the court specifically hasn't delegated to the guardian. Again, this is favored when possible, but there can be interpretations and oversight issues which do make it a little more challenging. An emergency guardian, again, this is only in extreme circumstances, usually only effective for 72 hours, can be extended. then a permanent guardian must be appointed. So who can petition for guardianship? Any person interested in the alleged incapacitated person's welfare. And you may often see, if you're like dealing with guardianships or like forms that have to do with guardianships, the alleged incapacitated person is always going to be abbreviated the AIP. And in court, a lot of times they'll reference them as the AIP. So when the anyone interested in the AIP's welfare can petition for appointment of guardian of the incapacitated person. That individual cannot have interests that are adverse to the incapacitated person, and it could be an individual or an agency. Where do we file? The interested person would file the petition with the relevant orphans court. So orphans court is kind of a division of your common pleas court. The petition's filed in the orphans court in the county where the alleged incapacitated person is domiciled or resides. So for example, if they're in a facility, it's usually where the facility is located, not necessarily where the guardian is located or the proposed guardian. What's in your guardianship petition? So you're always going to have the name and the address of the AIP, so the alleged incapacitated person, age and date of birth, names of parents, spouse, or children if applicable, the presumed intestate heirs, so that's really your next of kin, nature of the disabilities, proposed guardians, value of the estate, if there is one. So again, everyone has an estate. So when we're talking about your estate, kind of like financial picture, net income from all sources, why guardianship is necessary, and why other less restrictive alternatives to guardianship weren't feasible. We also need the qualifications of the proposed guardian. A criminal background check has to be done within the last 6 months for any proposed guardian as well. So when you file your guardianship petition, what you'll get back from the court, usually not immediately, but they'll send it to you relatively quickly, is a citation. And the citation is going to have like a hearing date and everything on it. The citation is going to have information basically telling the alleged incapacitated person basically that these proceedings have been filed. It's a written notice. It has to be a large type, simple language. So that the alleged incapacitated person can understand. It has to indicate the purpose and the seriousness of the proceedings and rights that can be lost if you don't contest anything. The notice has to state the time and the place of the hearing, the rights of the incapacitated person, including the right to be represented by an attorney and to have counsel paid for them if the alleged incapacitated person cannot afford an attorney. So then your petition and the citation, which is going to have the hearing date and all the relative information, is going to be served on the alleged incapacitated person, all of your next of kin. So basically anyone who would have an interest in your estate. So you might see next of kin, you might see intestate heirs. Any residential provider or service provider typically also have to be served with a copy of the petition. The petition and the citation have to be personally served on the incapacitated person at least 20 days before the hearing. You can have someone, and oftentimes like we'll go read it and kind of explain everything to the alleged incapacitated person if our client is the person that has petitioned the court for guardianship. I believe you can have a sheriff do it, although that seems a little bit much. The contents have to be explained to the maximum extent possible in a language the alleged incapacitated person is most likely to understand. Proof of service that this has been done has to be filed with the court before the hearing. Again, the alleged incapacitated person has the right to be represented by counsel, and if counsel can't be afforded, then one has to be paid for by the court. Any heirs, so these are these intestate heirs again. So if we're looking for closest living relatives, so if you're petitioning for guardianship of your child, usually any siblings above the age of 18 and parents have to sign consents saying that we consent to the filing of this petition, we consent to the appointment of so-and-so as guardian. After all of that is done, so you've done a lot of the administrative work, there's a hearing that's held in the orphans court. The hearing's in front of a judge. You have to present medical testimony from a doctor or licensed psychologist. In Pennsylvania, there is a expert deposition form that is kind of uniform. So most doctors are familiar with this if they deal with people with a alleged incapacity. So they were probably familiar. So you want to make sure it's usually you're not having live testimony. I mean, some courts again now are requesting or requiring that, but typically it used to be that the expert report was sufficient if that's presented by the doctor, and it's going to outline kind of the strengths and the weaknesses of the alleged incapacitated person. Like, do they need help with financial things? Are they like self-aware, things of that nature? The alleged incapacitated person is required to be at the hearing unless the doctor certifies that his or her mental condition would be harmed if he or she attended. Okay, I was the petitioner, yeah, typically paying for the evaluation. So usually, like you're having your doctor or your primary care, someone do this evaluation, or a psychologist that's already seen you. You don't want kind of a new person coming into the scene who's never treated or met with the individual that you're petitioning for guardianship of. You want someone that's had like a relationship there. So the evidence for incapacity, it's a clear and convincing evidence standard. So that's the second highest evidence standard. The only one higher than it is like the beyond a reasonable doubt, which is in criminal cases. So petitioner must present testimony in person or by deposition. That's what we were talking about, that expert report, by an individual qualified by training and experience. So a doctor or licensed psychologist in evaluating individuals with capacities of the type alleged by the petitioner as to the incapacity here. The person completing the expert or providing the testimony must complete an expert report, which is used uniformly in PA. So again, it's always most ideal to have like the treating physician, treating psychologist, the person who has been working with the alleged incapacitated person complete this report. If you go to your son or daughter's podiatrist and say, can you fill this out for me? I mean, it's not going to have as much weight if you're going to the primary care person or the psychologist that they've been seeing for years and years and years. So you want someone who knows the individual and who knows kind of the issues that we're dealing with. So the testimony of the guardian. So typically, again, the guardian is going to provide testimony when in court. So the name, address, relationship to the incapacitated person. So, hi, my name's Kelly. I live at 123 Cherry Lane. I am John Smith. Probably have the same last name as me. I am John Hayes's mom. So family relationships and dynamics. So you're going to talk about where John lives, kind of what he does, kind of his relationship with the family, physical, mental, social functioning, current placement, future plans, talk about any significant assets. Again, this is if we're talking about guardianship of the estate, public benefits. Is he receiving any sort of Social Security benefits? Is he receiving Medicaid? Is he likely to receive it in the future? Like, so John just turned 18. Are we going to be applying for SSI benefits in the future? And does he have any estate planning documents in place? Is there a power of attorney? Like, was there something less restrictive that we could be using here? So you had your hearing, the court agrees that a guardianship is appropriate, whether plenary or limited. You'll get a court order kind of listing all of your new responsibilities and powers there. After you get that order, the incapacitated person has to be served with notice of his right to appeal. So served with the order, served with the notice of right to appeal. Typically, you have to file an affidavit too with the court that says, yes, this notice of appeal has been provided to, read to the incapacitated person at this point. At any time, the incapacitated person can request a review hearing with the court to show a change of circumstance. I think this was the question from earlier, and why guardianship is no longer necessary. So it can be reviewed at any time. So for example, if you were in I think it even said in the question, there was a car accident, there was some sort of trauma, something like that. Guardianship was appropriate at one point, but now we've kind of gotten over that hurdle. Things are going better. Maybe guardianship is no longer appropriate. You can request the court to review everything. And then depending on the outcome, maybe there's a more limited guardianship, maybe there's no guardianship at all. If that is the case, then I would recommend putting a power of attorney in place. So when the court makes their order, they're making a determination of incapacity. And I've cited here the statute. So this is what the court has to consider and make specific findings on. So you want to make sure in your petition or in your testimony that you've addressed these, because the court is looking for the nature and the condition of the disability, which impairs the individual's capacity to make or communicate decisions. So like, what's wrong? Why do we think we need guardianship here? The extent of the individual's capacity to make and communicate decisions. So can John make some healthcare decisions? Is he just really bad with numbers and like all and like if we're talking about an intellectual disability, like really is not able to handle finances, something of that nature. The need for guardianship services in light of such factors as the ability of family, friends, other supports to assist the individual in making decisions, and the existence of any advanced directives or durable powers of attorney. So again, like the court's looking if there are family, if there is a support system in place where guardianship may not be necessary, like that's what they're looking for, that less restrictive alternative. Type of guardian, again, the court's going to make a determination about limited or plenary of the person or the estate is needed based on the nature and condition of the disability and the capacity to make and communicate decisions. The duration of the guardianship, usually you see most like guardianships don't necessarily have an end time, at least not that I have seen recently, but again, they can be reevaluated. I know I've dealt with a lot of transferring guardianships from out of state, and like some states do have requirements where guardianships are just reviewed automatically every year. Not as much the case here, maybe that'll change. And then the court should or shall prefer limited guardianship. So again, that's in the statute. So unless there are extraordinary circumstances that require that plenary guardianship, the courts are statutorily supposed to prefer that limited guardianship. So a power of attorney isn't required to get a background check, but again, like you probably don't want to be appointing someone that you don't trust or who might not be the best person for that role. Like there's no criminal background check required for a power of attorney. There is for guardianship, so it has to be done within the past 6 months. Contesting a guardianship. So if guardianship is filed, like you get notice of it, you would go to court and you would kind of present your case, like why guardianship isn't appropriate. I guess I should have said that every person is presumed to have capacity regardless of their disability. So the burden is actually on the petitioner. So the person is requesting guardianship. So they have to prove that it's necessary, it's the less restrictive alternative. I think this is Kelly's question. You would go to court and you would contest kind of at that same hearing. If we became POA for medical and there was another POA, there are, I guess from a power of attorney standpoint, sometimes you can see like a combined power of attorney, which will give you a general durable power of attorney that has both medical and financial powers in it. Oftentimes you'll see them as separate documents. So there is a document that is specific for all of those financial powers, and maybe you have one agent for those. Maybe you've determined that you want a different agent to make those healthcare decisions for you. Powers of attorney, all powers of attorney would be preferred to guardianship if you were asking the court. Duties of the guardian of the person. To act in the incapacitated person's best interest, to respect expressed wishes and preferences to the greatest extent possible, encourage the incapacitated person to participate to the maximum extent possible in all decisions that affect him. Again, we're promoting that self-determination, autonomy when possible, general care, maintenance, and custody of the incapacitated person, making sure, so one of the main duties of the guardian of the person is making sure that that incapacitated person has somewhere to live. A guardian of the person is required to file annual reports with the court. There's a guardianship tracking system now, so you can file them all electronically. If you do not file your reports timely, and some counties are better than others, but they usually start generating these notices. And then if you ignore the first notice, then you get another notice that you have to come to court and kind of show why you should still be allowed to be the guardian. Duties of the guardian of the estate. So again, you're acting in the person's best interest, you're safeguarding assets, managing assets, paying debts, obligations, expenses. The annual report for the guardian of the estate is a bit more extensive than the annual report for the guardian of the person. Again, if you don't file it, you'll get those warning notices, and then you'll be called into court to kind of explain why you've disobeyed this obligation. You have a fiduciary duty to the incapacitated person when you're the guardian of the estate, and you're legally obligated to use prudent judgment. So kind of similar standards there to that power of attorney. You're a fiduciary when you're a power of attorney, and you have to use prudent judgment when dealing with someone's assets. Within 3 months of the guardianship hearing, guardianship order, you have to file an inventory with the court. So the inventory is, okay, a snapshot of what the financial picture is on that date. So it's going to kind of list all assets, and it'll make sense if you're kind of looking at all of the annual reports, because everything will run off of that inventory. So if you're saying you had $100 here, and then you have to kind of explain where the $100 went in the annual report, it kind of just keeps building.
Kelly, someone asked what types of reports are required. So can I assume that you have to report on the duties that you just listed there? For example, if you're the guardian of the estate.
They are forms, and I mean, any county's orphans court website is going to have the guardianship forms on them available. And there is now this guardianship tracking system. And I'd have to look specifically about Lehigh County and Northampton. I'm sure everyone uses them now, but you can do them electronically, but they're not forms. They're not reports that you're generating on your own. They are standardized reports that you just have to complete on that annual basis. What are some of the less restrictive alternatives to guardian of the person? So the healthcare agent, if you have the capacity to appoint a healthcare agent, that's going to be less restrictive. Advanced directive living will. So the advanced directive and living will is really only going to provide your agent guidance if you're in an end of life situation and there's no hope of recovery. It's basically like, would you want extraordinary measures at this time? But again, kind of whole picture, like a lot of times people do healthcare powers of attorney in conjunction with advanced directives and living wills. Healthcare representative. Pennsylvania has what's called a healthcare representative statute, and I think I have a slide on this coming up. But basically what it does is it kind of outlines a priority of who these decision makers would be if there is no power of attorney or if there is no guardian. I will say again, particularly in Montgomery County, Pennsylvania, there is a push. So if you say, I need to be a guardian of the person because I need to help make these medical decisions, I need to get information from doctors, you will be directed to like that healthcare representative statute, which is going to give you the authority to make those decisions. I've even seen like when guardianship may be determined to not be the less restrictive alternative, is some courts will issue an order. So you have a piece of paper in your hand that says you're appointed as like this, you are the healthcare representative. So like kind of when you have the piece of paper in your hand and you go to the doctor's office or you're in the hospital, it has a little more teeth to it. I would say within the past few years, more hospitals and medical facilities have become more familiar with that healthcare representative statute. So they know that there are certain individuals that can make decisions, can participate in decisions for people who don't have the ability to make them, even in the absence of the guardianship and in the absence of the power of attorney. Family and community support, supported decision-making, and case management services. So all of these things could be alternatives to guardianship of the person and would be preferred when appropriate. So here is the healthcare representative statute. It provides for family members, again, in that like list of priority, to have authority to make medical decisions for a person that lacks capacity. So your order of priority is going to be spouse and adult children of the principal, who are not children of the spouse, an adult child, parent, adult brother or sister, grandchild, and then there's a catch-all, like an adult who has knowledge of the principal's preferences and values. So again, I think one of the goals of the healthcare statute was to provide the ability to have someone who knows what the healthcare wishes of an individual would be, to be able to provide that without having to go through those guardianship proceedings. So an individual, so if you have sound mind, you can in writing inform your doctor or medical provider that you're designating one or more individuals as your healthcare representative. And then in the absence of that designation, we're going to go with the order that's listed here. Supported decision-making. So it allows an individual with a disability to turn to a trusted friend, family member for help in making major life decisions. Supports the idea that individuals have the legal right to make their own choices. Individual retains the right to make their own choices with support and guidance from others. So Pennsylvania does not have a supported decision-making statute, and not all states do. Delaware did just recently pass one, but again, kind of with the kind of like the renewed push of the disability rights community and everyone like kind of pushing away from guardianship when not appropriate. I mean, there is the possibility that maybe there will be some sort of supported decision-making statute in Pennsylvania, hopefully sooner than they raise the amount that an individual can have in their account for Social Security purposes. So again, also it is a possible less restrictive alternative to guardianship. What are the less restrictive alternatives to guardian of the estate? And I know I'm getting very close to the hour, but we're going to wrap it up and then we'll be able to answer more questions. Power of attorney, again, your financial power of attorney, special needs trust. And again, so if you have a special needs trust, there's different types of special needs trust, but that could be a whole other presentation. It's important if you have a loved one who has a disability or a loved one who is receiving those like means tested government benefits that you do make provisions for them when you're doing your estate planning. So what I mean is, you're probably aware that if an individual is getting those SSI benefits, if they're getting Medicaid benefits, you're always trying to keep their accounts under that $2,000. So if you are to inherit more than $2,000 or I guess even a smaller amount, if you already had some money in your bank account, that is potentially going to impact your eligibility or disqualify you from benefits. So a way around that is if you're going to leave someone who's receiving benefits, if you're going to leave someone with a disability, a share of your estate, if you want them to inherit from you, you want to make sure that you create a third-party special needs trust. Sometimes you might hear supplemental needs trust, and make sure you're directing those assets there. It's also important if you have beneficiary designated assets, so your life insurance, your 401ks, retirement accounts, that you're directing them to a special needs trust, because it's all well and good to create the special needs trust and say, everything under my will goes here, but if those beneficiary designated assets are going outright, we're still causing the same problem. ABLE accounts. So again, an ABLE account is a good way to provide resources to an individual with a qualifying disability, and you're not necessarily going to need a guardian to kind of manage those accounts. A representative payee, if all you're receiving is Social Security disability income, that's really not going to be a reason to appoint a guardian of an estate. So again, that representative payee, the funds can go into an account that you're a representative payee on. You can manage those funds, kind of pay them out for the individual that you're serving in that capacity for. And then that supported decision making, again, like you're assisting with shopping, you're assisting someone with paying bills, etc. So again, trying to help them remain as independent as possible. So you went through all this guardianship, you got your guardianship order, and then you decide that we're all moving to the whole family's picking up and moving to a different state. Do I have to start this over again? Most, I think it's up to like 40 some states have adopted the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. I will tell you that some are much easier to deal with than others. But essentially it's supposed to be a 4-step process. It's a lot of back and forth, and someone probably should consolidate it. But I don't know if that's on a high priority of anyone in our legislature. But what happens is you file a petition in the state where you have the guardianship. So if I'm in Pennsylvania and I'm moving to, I'm moving to like Massachusetts or something, I would file my petition in Pennsylvania requesting a provisional order to transfer guardianship to whatever county in Massachusetts that I'm moving to. Once you get that order, a similar petition would get filed in Massachusetts with a certified copy of the order saying, hey, Pennsylvania is willing to transfer this to you. And then you get what's called a provisional order to accept the transfer. So there's a lot of back and forth here. So then you get the provisional order to accept, and then you have to ask the transferring court. So I'm back in Pennsylvania. okay, I have this provisional order to accept the transfer. Can you issue your final order and then terminate the guardianship here? And then once they do that, the accepting state, so Massachusetts, in my little scenario, issues their final order accepting the guardianship and then can modify the guardianship order from Pennsylvania to conform to Massachusetts law. So you can do that with, again, most of the states. And the idea is each state is supposed to kind of accept that the transferring state did their due diligence, followed all of the rules, dotted the I's, crossed the T's, and they've already made the determination of incapacity and everything like that. So you don't have to go through that whole process again. You're just asking that the courts kind of honor those guardianships from other states. Sometimes it would have probably been easier, in my opinion, to just start over. But again, it's a state by state basis who you're dealing with. And that is all I have. And there are lots more questions in here.